Hey guys, quick video on professional liability insurance. Kind of a obscure topic, but I think it's interesting just because a lot of money is involved. Here in society, we have something called insurance, which is basically pools of money that's available for tort claims. So professional liability insurance, typically procured by professionals, um, legislation grants bodies some sort of authority to prescribe the activities, the professional activities defined of its members, such as nurses, what are nurses allowed to do, engineers, architects, psychologists, lawyers, etc. So these professionals provide services to the public, which are very valuable, extremely important to the community, and at the same time, there can be a special risk of harm, that there's a risk a professional would breach some sort of standard, either implied by law or contracted, a certain standard of care. Usually that standard can't be too extreme for the sake of setting up insurance, but typically insurers will insure a range of a standard of care if it's defined in a contract. And if that professional makes an error or omission and fails to do something and it causes damages, they broke that standard and it caused harm to somebody, that harm can be quite significant. It could cost a lot of money. It could seriously harm property, people. Now, direct harm, of course, through property or damage to people could be generally covered under general commercial liability insurance. But here we're talking about professional errors that cause harm, mistakes, and so on. So this is a pool of money that's available. And so, when professionals are offering services to the public, people approach them and they have an interest in saying that they're going to be protected, that there might be some money available, even if it's just a single professional working out of their basement kind of thing, providing good services, but their services could still cause a lot of harm, and they might not have that pile of money. Even if you sued them, even if you won in court, there would be no money available. You couldn't enforce that judgment. That you can't get blood out of a rock, as the saying goes. So people often ask, do you have insurance? Let's see some proof you have insurance. Now, a lot of these self-regulating bodies require their professional members to maintain insurance. For example, in the case of lawyers and often physicians, they're required, or nurses are required to have insurance. But maybe they're not practicing, or this or that, or maybe there's some kind of quasi professionals or that are maybe less regulated, that their insurance is quite flexible. How much do they have? Do they have extra insurance? How much? So there's this whole question of what money might be available, and that's why people buy these insurance policies. So for example, let's say somebody wants $10 million of insurance. Maybe it's because the person who's hiring them says, I will not hire you unless you have $10 million of professional liability insurance. Or maybe their regulatory body requires them to maintain a certain amount of insurance. But let's give the example of $10 million pile of money that maybe was at some point available. It may have been diminished over the course of the period through a series of claims, but let's say it started at $10 million available. How much does that cost for the professional to procure that policy? Well, it might be a few $1,000s on the cheap side. I would say $8,000 for a lot of professions. Lawyers or psychologists might be a little bit less, but it could go up. Let's say maybe a physician specializes in childbirth. It could be, I don't know, $100,000, $200,000 per year. Now, of course, in Canada, who's paying for that insurance? It's not the doctor. There is a very large treasury funded by the public that pays for the doctor's insurance. Now, those policies might actually cost $4 million. A $10 million policy could cost $4 million in some instances, such as a project-specific professional liability policy. This would be, again, this is all based on the risk of the services, the likelihood of having to pay out that sum of money. So, for example, if maybe an engineer or someone's designing a certain piece of infrastructure, like a building, and they say, okay, this is a particular project I'm working on. I want insurance just for this, construction of this project. That can be really expensive. It's like, this particular project, what's the risk of these particular, buildings or whatever is being constructed, right? So again, it depends on the likelihood of paying out. Of course, insurance companies want to make money. At the same time, they're providing the service of this money that's available. So that's a little bit of a high-level overview of insurance. So let's give an example now. Let's talk a little bit about waivers of subrogation, which is a more obscure topic within professional liability. Let's give an example of, let's say you set up a business and you want to sell equipment to amusement parks. So you have these great idea of spinning teapots or something like that, and you go to amusement parks and somebody buys it. Yeah, I want that spinning teapot in my, amusement park. And so you say, great, it's this beautiful design. I have this great idea. I'm going to hire someone to design it, design the metal, the gears and everything. So they hire an engineer, and that engineer makes a mistake in the design. Well, first of all, you win the job from the owner. You have a contract with another engineer who's going to help you design it. And in that contract, you said, okay, I want to make sure my engineer has insurance, first of all. I want to see proof that you have $10 million of professional liability. So you get the certificate. Yes, they have this insurance. Oh, yes, you're also an additional insured. So if the owner sues you, that policy is also going to protect you. Okay. And then the engineer makes a mistake. Let's say they coated in some metal that's stripped down or something like that. Now, the owner of the amusement park discovers the error, the equipment's not working properly, and they turn around and sue the engineer. They could sue you too, but let's say they sue the engineer in this example. The engineer's insurance company gets the claim, takes one look at it, be like, oh crap, for sure the engineer made a mistake. Like, there's just no denying it. Unfortunately, we're going to have to pay out this claim. Let's not go to court and have lawyers involved. Let's just go ahead and, we'll pay for the equipment. We'll pay for you for a little bit of, whatever. And, we'll pay for remove the old equipment, give you new equipment, okay? Now, the insurance company settles that claim without you even knowing about it. And then now the insurance company turns around and sues you. Says, oh, we had all these damages. You were involved in this project too. We have $8 million of damages now. Here's the bill. You pay up. We're going to countersue you. That's called subrogation. So the insurance company subrogated against you because they settled the claim without first getting you involved or notifying you or involving you in the claim. And then they just immediately settled the claim and they countersued you. So that's subrogating against. And now, a lot of policies do allow for waivers of subrogation. So in that contract with your engineer, you might have said, okay, the engineer promises to waive subrogation against you. And moreover, you make sure that his certificate of insurance says on it that the insurer waives subrogation against you. We will not subrogate against you. That means if, the owner sues the engineer before the insurance company just goes and settles the claim, they're incentivized to communicate about it. Hey guys, let's get everybody involved. Who has notes? What happened here? Who is involved? We're not going to countersue you for the damages, so we have to make sure we've worked it out first. And, who contributed to this, how much, and then the claim is resolved. So that's what a waiver of subrogation means. Insurance companies would make you probably work for that. They won't necessarily put that out there. If you don't have evidence on the certificate of insurance, if you just have a promise, a contract with the engineer that they're going to waive subrogation on behalf of their insurer, That's not going to be good enough. You're going to need it on that certificate of insurance. A lot of policies would allow that kind of um, waiver to the extent of a written agreement prior to the event or circumstance, but they won't hand those out willy-nilly. Mostly in that kind of circumstance, they won't waive subrogation against the owner. Usually, for example, they would just waive subrogation against the client. Some policies don't allow waivers of subrogation. And again, the brokers will often say, oh yeah, no, sorry, we can't provide that for you. And then it's like, okay, show me in writing, prove to me that you cannot provide this. So, insurance companies really make you work for this, because this is like where a lot of money is made and lost. Insurance companies, in my view, what they do is often make it the path of least resistance is the way the insurance company kind of makes money. And so you sort of have to sometimes kind of fight for stuff a little bit, be like, hey, this is a service I expect, and so on. This is what we need. This is what our contract says. If you want, this professional to keep retaining you and buying insurance from you, this is the standard in the industry. This is what we're going to need, right? So that's a little bit random facts about professional liability policies and waivers of subrogation.